it's been said that it is a sensitive issue, it is a very important issue, and this is also to say that the issue of I'm speaking about, which is independence and the appointments of judges, it is also a political issue after all. And the significance of the appointment system, which is kind of a technical, you would think it's a technical issue, how you appoint judges, and sometimes you can find it a bit boring and procedural. But a lot of the debates and discussions are about who we appoint as judges, and all the political struggles are about, a lot of the political struggles are about who is going to interpret the law. So one issue is what the law says, and then the other issue is who is actually going to interpret the law. What political affiliations there, what philosophical views of that person may be. So it's quite an important, and as the famous notorious dictator Joseph Stalin said, it doesn't matter, I mean, it's a famous saying, sorry, but that it's so, it fits so much our discussion today. It doesn't matter how they vote, it matters who counts the vote. So this is actually at the core of the issue. And this quite bad saying actually tells how important, and the issue is that the procedure follows, that the appointment is actually transparent, and we have trust in the judiciary through the appointment procedure. So I have quite many, I have to say, I'm looking now, it's 25 slides. I won't do them all, I won't have time, but I will run through them, and you will have them also as reference, because each of them, they have links, including clickable ones. So this is also just for reference, for your reference. And sorry that I'll be speaking here, but you would need to also read sometimes on the screen. So there'll be our exercise, how to do two things at the same time. The first point I want to say, we've already said, the significance of the issue. It's such a significant issue that it's been said many, many times that, in fact, through the appointment procedure, we actually ensure the legitimacy of the judiciary. So that the society actually sees these people as legitimate bearers of this authority to interpret the law. It was said in the opinion of CCJE, but also in the Iceland famous case, where actually the European Court elaborated on this issue of legitimacy, using this very language, that each judge obtains his or her constitutional authority and legitimacy through the appointment procedure, and then that the authority and appropriate powers are given like this to interpret the law. So without a procedure that is transparent and meets certain requirements, a person wouldn't have the legitimacy of a judge. So this is at the core of the issue. And in the next slide, we can see that it's also related to the appointments, to the issue of independence. So very often we hear about attacks on the judiciary that have to do with sitting judges. But in fact, it starts at the judicial career starts with the appointment. And the issue of independence goes again to the very beginning of the career of the judge, to the appointment. And as the Cape Town principles, you can see the reference, and they're very well captured this idea that the ability of the judiciary to discharge the responsibility, their responsibility, judicial function, depends really on the independence, impartiality, integrity, and competency of the members, which is the principal objective of any system of judicial appointment, is to identify and secure the appointments of persons who possess these qualities. So this is the whole point of the appointments procedure, is to actually identify the people who can ensure the independence of the judiciary. And this again was mentioned by, in many cases of the European Court. We now speak in the European Court judgments. These are general principles, but we can see in the recent jurisprudence of the European Court how this exact principle is in fact interpreted and applied by the European Court. But in this test that the European Court has elaborated, the objective of the appointment selection procedure should be ensuring the independence of the judiciary. So this is in fact the whole point of the appointments procedure. The same principle is repeated in the Human Rights Committee General Comment, where it says where the Human Rights Committee again reiterates that the independence in particular includes the appointment procedure of judges, and that's an essential element of independence. Now, since maybe we don't have too many people who were in the first event, where I also used parts or most of this presentation, but it's important to look at the elements of this independence, what independence actually mean. Without elaborating too much, you can read that independence includes independence in law and in practice. And we have to see that very often states like saying that, you know, in law, it's not anymore even the case in every country. Sometimes now the executive is not shy to often introduce the procedures which even in law are problematic. But it has to be guaranteed in law and in practice. It has to be institutional and it has to be personal. So that the structure has to be ensured that the structurally it's independent, that judiciary as an institution independent, but also isn't independent, but also that each judge is independent on in their decision making. And there has to be external independence from other branches of the government and internal independence of each judge from within judicial hierarchy. And this is very often a problem, the problem that, well, you can guarantee independence from the parliament maybe sometimes. I mean, again, we're speaking about separation of powers, really will be another slide. But so it's interdependence very often rather than complete independence. Of course, we speak about interdependence and checks and balances system of all the branches of power. But there has to be also an internal independence that has to be secured within the judiciary. So you can see in the next slide some of the main elements of this. I elaborated a little bit more about, on the issue of external and internal independence. You can see here some of you can read some of the points there on external independence, that the states have to be take specific measures to ensure it, that there has to be sanctions when someone is trying to influence judges. So this is part of the obligation. And the internal, so this is about external and internal independence. You see that judges have to make, to be able to make the judgments in an impartial manner without any interference. And that the role of Supreme Courts should be limited to judicial functions. So again, it's important to stress that it's an issue of the separation of powers at the core of it. And this has been repeated by various international bodies. It's just 3 examples, I have to say, but there are really many examples where this principle is mentioned, and we have to just keep it in mind that, again, we always, so we're interpreting each case, we actually are speaking about the issue of separation of powers. And this has been, the global picture is always how the state powers are able to counterbalance each other and serve as a check against each other's sometimes maybe arbitrary actions. And of course, the judiciary very often is quite vulnerable without having an army of its own. Now, going to the aspects again of independence, just three main, this is a general kind of overview, that there are three elements where we normally can see where the pressure points for putting pressure on the judiciary. It's the qualification and appointments procedure, is security of tenure for judges that they can actually serve throughout. And then there are all various issues related to promotions, transfers, suspension. These are also pressure points where whoever wants to influence in an undue manner the judiciary or a specific judge, they can actually use these. These are the pressure points that we have to look at. Now, speaking very briefly about actual standards when it comes to qualifications and appointments of judges, international standards. I didn't say where each of these criteria is mentioned, but you can, again, there are many slides, you can see what we relied on when trying to list some of the key ones. They're just key ones. So it's the method of appointments, that there has to be a body which is using the criteria established by law, and this body is actually competent and independent. That the appointment procedure should be open to public scrutiny. This is a very important point, that the appointments procedure has to result in the trust of the public in the procedure. And this is achieved through ensuring that the appointments procedure is open to public scrutiny. Again, this is an international standard. We're speaking about specific standards that we take from the documents. It should be based on merit. And it again has to be clearly defined. There are some documents which elaborate a little bit further what exactly these the qualifications should be. But this is important, that it has to be based on merit rather than preferences, of course, political or otherwise. It should be free from any discrimination. And it has to be also, it has to result in diverse judiciary that reflects the general composition of the society, and linguistically, ethnically, otherwise. Appointments should be done by an independent authority, and we here can speak a bit more. Last time at the last event, or the previous event, we spoke about the role of judicial councils. I included here, we don't have time to go into it, but judicial councils, in fact, are these key bodies which are entrusted very often with this role to select, to assess the judges. And they are in this, they play this unique role while not being exactly subordinate within the hierarchy of the judiciary, but at the same time free in principle by the international standards from pressures from the direct pressure from the executive and the legislature. And there has to be always a mechanism to challenge the decisions. And it has to be, of course, a judicial mechanism, so there has to be a remedy provided. I just have to remind, and maybe the next slide is additional appointment requirements. It has to be generally for life. Temporary judges should normally be avoided. The composition of Supreme Courts, or in courts in general, should be stable, that the executive shouldn't have the powers to single-handedly decide on the composition of the, for example, of the Supreme Courts. Now, when a violation may occur, so maybe there are a couple of more slides there just to say, just point to a couple of documents that we relied on. This is UN basic principles on the independence of the judiciary, recommendation of the Committee of Ministers, and reports of the Special Rapporteur. It's more or less, I won't read them, you can see them on your screen, and they reflect some of the standards that I've mentioned. And just maybe to say, coming to an end, because I'm aware of the time, we have to say a violation as decided by the European Court. There's this three-stage, three-point test that you have to look if there's a manifest violation of the national law. So when we speak about the general violation, this is speaking about the appointments procedure, that there's a manifest violation of the national law, that you identify that there was a breach of the purpose of the appointment, which is in fact ensuring the independence of the judiciary. This is the second test. And the third test is that you had judicial remedies, and that there was a judicial recourse and scrutiny by the judiciary of the matter. So I would just go run through very quickly through the other slides. Very quick. Yeah, no, I won't. I'll just go to the end. So this is it, just to say I've made all my points I wanted to make. But just to go to the end, you can see that about the powers of judicial councils, just highlighted that one of the key powers is to actually selection and appointment. You can see there that this is one of the main functions. In the ENCJ compendium, it also says that the appointment of judges. And then some of the standards you can have, if whoever wants to look at these slides later after the event, you can have some of the standards, you can see some of the standards concerning the composition, the role of the judicial councils. And finally, at the end, we gave some of the international documents which you can use, and each link is clickable. Here, this slide, actually we wanted to stress that this is not just soft law. We're speaking about the right to an independent, to a fair trial, to an independent court, and this is actually a right that you can defend in court. And finally, some of the standards you can see specifically concerning the judicial appointments and other general sources concerning the independence of the judiciary, both global and European regional ones. Yeah, this is the end of my presentation.